Earlier to this Competition Act 2002, we had this MRTP Act. So earlier we used to follow this MRTP Act, but now we are following the Competition Act 2002. If the agreements are not according to the Competition Act, then those agreements will be considered as anti-competitive agreements under Section 3, subsection 3. If you feel that the company is dominating more, then based on these reasons, we are going to decide whether that company is more competitive or not. Hello everyone, I am Arun Kumar, lecturer in Department of Commerce and Management, Vidhyaashram First Grade College, the Temple of Excellence, Mysuru. Dear students, welcome to this new session, that is session 5 on unit number 3. The chapter name is Competition and Consumer Laws. Yes, in the earlier session we discussed more about what is this consumer law and what and all we are supposed to look into, or what and all we are going to learn in consumer law. And we also got to know about the different types of consumer forums what we have in district, state and central level. And in the earlier session we also started with our Competition Act. So in this session we will be continuing about the Competition Act. So the objectives of Competition Act 2002. So in order to bring a healthy competition between the business entities, so this act came into existence. In order to abolish the monopolistic market, this Competition Act came into existence. So we discussed the meaning in the earlier session. Now we are looking into the objectives of Competition Act 2002. So what are the objectives? Why this act came into existence? Why they brought this act in the year 2002 in India? So with what intention? What are the main objectives behind this act? So the Competition Act 2002 is a law that aims to protect the interest of customers from anti-competitive behavior, encourage and maintain market competition. Yes, the main intention, the first objective is to protect the interest of the customers from anti-competitive behavior. What is this anti-competitive behavior? So sometimes in order to attract more customers, in order to increase the sales, what this business entities will do? Just they mislead the customers and they increase the sales. So to avoid this, in order to protect the customers, this law came into existence. Next, it encourage and maintain market competition. Yes, it encourage and maintain market competition. What is market competition? Yes, we will be having different types of companies and those companies is competing with each other. In that competition, there should be a healthy competition. There should not be any confusions, or so there should not be any kind of misunderstanding, or there should not be any unhealthy competition between the companies. Next, defend consumer rights. Yes, this act's main objective is also to defend the consumer rights. So what and all the rights a consumer will be having? He'll be having all the rights to question about the quality, quantity. If there is any defect, he can question. You can question about the price of the product. You can question about the ingredients which are used in the product. You'll be having all the rights. So to protect those rights, this law came into existence and ensure the freedom of trade of other market players. Yes, here in order to ensure the freedom of trade, that is in order to ensure the freedom of free trade, that means the companies, whichever the company is, whether it's a small company, big company or medium company. So any company can compete with anyone and they can sell the product wherever they want. So in order to protect the small companies or the medium scale companies also, this law came into existence and the objective is to protect all kinds of companies and to make them to trade freely in the market. And the new legislation has replaced the old MRTP Act. Yes, earlier to this Competition Act 2002, we had this MRTP Act. So earlier we used to follow this MRTP Act, but now we are following the Competition Act 2002, which only previously applied to India and prohibited monopolies and other restrictive trade practices. Yet earlier we following the MRTP Act, where that MRTP Act used to give us the protection against the monopolies. That means where there will be only one seller and he used to demand for more price for the particular product whatever is giving without compromising with the quality and the quantity. So in order to protect the consumers from monopolistic market, this MRTP Act was in existence earlier to the Competition Act 2002, but now we are following the Competition Act 2000. The Competition Appellate Tribunal, the Competition Commission of India and the National Competition Policy are the three primary parts of the competition law upon which the Competition Act was constructed. Yes, this Competition Act is constructed based on the three primary parts. So which are those three primary parts? That is Competition Appellate Tribunal and the Competition Commission of India and the National Competition Policy. Next, this regulation is passed typically to make sure that market competition features as supposed and that purchasers can get access to a much broader variety of goods at the honest cost. Yes, this law came into existence with the intention of providing a free trading platform to the sellers of the products and to make sure that the customers are going to get the different varieties of products with a reasonable price. The penalties and offences under Competition Act 2002. Yes, under Competition Act, when they are going to impose the penalties. Okay, when they are going to impose the penalties and when it will be considered as offense, in what situations the trade or whatever the things will do, when that will be considered as a offense. If any enterprise or individual fails to abide by the orders as well as directives of the competition made available under section 27, 28, 31 for any irrational reason, the Competition Commission, which was formed with the primary purpose of protecting trade agreements, has levied certain violations as well as the penalties under the Competition Act 2002. Every instance of non-compliance increases the penalty, which might reach more than 1 lakh. So here, if any business entity is doing any kind of illegal activities and if they are not following the rules and regulations of the the Competition Act 2002, then those kind of people comes under this penalties and offences. Sometimes they are going to put a small penalties, and if the the mistake is big, then they will be paying the penalties in lakhs. Okay, they'll be paying the penalties in lakhs. The following the Competition Act 2002 provisions for legitimate business execution, the Director General is appointed by the Competition Commission of India or CII. CCI is nothing but what? CCI is nothing but the Competition Commission of India. So, in order to protect this particular law and in order to be as a president or as a main person of this competition law, they are going to appoint the Director General, who is going to be appointed as the Competition Commission of India. Next, the company can submit an application to the Appellate Tribunal for compensation under Section 53N of the Competition Act 2002. Yes, if the company wants to file any kind of request, they can submit their request or they can submit the application for whatever the compensation they are expecting for. And this features of Competition Act 2002. So what and all the features we have under this? The first feature is anti-agreements. So what is this anti-agreements? Anti-agreement is nothing but no person or business may participate in production, supply or distribution activities that would have a detrimental effect on India's competitive environment. Such agreements are considered illegal in any form. That means anti-agreements. If no person or if no business is participated in production, supply or distribution of any goods or services. If those persons are not participated in supply of goods or distribution of goods or production of goods, then the activity would be a detrimental effect on Indian competitive environment. And such agreements are considered as illegal in any form. So that is the main and the first feature of Competition Act. Next one, abuse of dominating position. Yes, abuse of dominating position. If a business or a connected person is discovered to have engaged in unfair or discriminatory actions, this is seen as an abuse of the dominant. That means the position under the Competitive Act 2002, the party will be the subject of an inquiry by the relevant authorities if it is discovered that they have abused their position. Yes, sometimes one person will be there who is dominating the whole market. For example, if you take any perfume, perfume as the example, now at present one company is dominating the perfume in the in a medium range, in the reasonable pricing strategy. One company is dominating the perfume market. Which company is that? Yes, that is the Fog. So in that case, if they are in the dominating position, if the position is abused, then you can go and complain against the person under the Competition Act 2002, and the party will be called for the enquiry. If in the enquiry, if they get to know that if the party is having any kind of mistakes, then that will be considered as abused their position. That means abuse of position, dominating position of a particular company. And combination. So what is this combination? According to the Act, a combination is a set of conditions that result in mergers or acquisitions. The Competition Commission of India would examine the parties concerned if such combination exceeded the restrictions set forth by the Competition Act 2002. So combination is nothing but acquisition or merging. So this acquisition or merging should take place within the given framework. In case if those acquisition or the merger, if it is not taking the proper rules and regulations, and if the combination exceeds, if the merger or the acquisition, if it exceeds the restrictions set forth by the Competition Act 2002, if it exceeds the rules and regulations which are framed by the Competition Act 2002, then at that time they will be looking into those merger and acquisitions. Next, Competition Commission of India. So what is this Competition Commission of India? Competition Commission of India, this independent organization has the authority to enter into a contract. So the Competition Act 2002 or the Competition Authority have the authority to enter into a contract, and if such contracts are broken, to bring legal action against the violation. Yes, if those contracts, whatever the contracts they get into under the Competition Authority, if those contracts broken, to bring legal action against those violators. That means whoever is going to breach the contract, to take action against those violators. The commission, which has a maximum of 6 members in charge of upholding and advancing consumer interest to the establish of optimum conditions for economic competition. Under the Competition Act 2002, the Commission's other responsibility is to provide advice to the Indian government on matters related to economic competition and raise public awareness of the problem. So here this Competition Commission of India is to take action against the people who are going to breach the rules and regulations which are formed at the time of getting into a contract. And also this particular organization, the Competition Commission, is going to give advice to the government, whether for the central government or for the state government, while they are taking decisions with respect to the economical activities of a particular country. Next thing is Section 3 of Competition Act. So what does this Section 3 says all about under the Competition Act? So Section 3 of the Competition Act 2002 prohibits any agreement between companies, or people that would materially undermine Indian competition. There are certain practices that are deemed anti-competitive under the Section 3, subsection 3 of the Competition Act 2002, including. So here the agreements, prohibition of any agreements between company or people that would materially undermine. That means if any kind of agreements are violating the rules and regulations of the Competition Act 2002, if the agreements are not according to the Competition Act, then those agreements will be considered as anti-competitive agreements under section 3 subsection 3, and we also have few agreements which will be considered as anti-competitive. Setting the price or any other trade conditions, that is price fixing or whatever, the price fixing and other conditions should be the trade conditions or trade related conditions should be according to the Competition Act 2002. If they are fixing as per their requirement without following the rules and regulations, then those will be taken care under section 3 and subsection 3 of the Competition Act. And regulating or controlling the provisions of services, investments, markets, technical developments or manufacturing, that is limiting production. So regulating or controlling the provision of services, investment, markets. So here this regulation should also be as per the requirement of the Competition Act. If these regulations are not as per the rules and regulations of the Competition Act, then they will be having all the rights to take action and to call it as a anti-competition activity or anti-competitive activity. Next, allocating a given geographical market. That means one set of area or one particular border is given to a particular seller or to a company. Those they are supposed to trade in that particular area. Almost in all the cases, what we will do, it's an open market. The world is an open market. Anyone can go and sell wherever they want. But for few goods, those people are supposed to trade in that particular area only. They are not supposed to go beyond that area. That geographical border or the geographical area will be allocated by the Competition Act people or the authority. A certain good or services, a specified number of customers or a production sources or market sharing. So here they need not to stick on to one particular area. They can go wherever they want. If the area is allocated, then they will be selling there. If they are free for trade, they can go anywhere they want and they can trade in the market. Next, obstructing or limiting the entry of rivals into the market. That means entry control. So here obstructing or limiting the entry of rivals into the market. That means here if any person is restricting the market, no one will be having the rights to restricting the new competitor or the new company in the market. That will be taken care under the Competition Act of section 3. And any agreement reached between the companies, groups of companies or individuals or between groups of people about the manufacture, distribution, allocation, storage or gathering or acquisition of goods or the rendering of services related to. That means any agreements which are relating to the distribution or manufacturing of goods or allocation of goods or area or storage of goods or gathering of the material or the resources or the acquisition of the goods or the services or rendering of services relating to development and research. That means again this section 3 of the Competition Act, it also deals with the any agreement between the production activity or rendering of services or acquisition of goods or producing of goods or manufacturing of goods. In that, the development and research, that means this law and helps with development and research, technical data, standards, evaluating resources, access to cutting edge technologies, marketing, activities involved in exports. With this, they are going to, with respect to this kind of aspects, they are going to take care under section 3 of the Competition Act 2002 and section 4 of the Competition Act 2002. So section 3 deals with all kinds of agreements between the the parties or between the authority and the parties and about what and all they talk in section 3. Section 4, along with excessive dominance and anti-competitive agreement, the dominating position is another factor that the Competition Act 2002 outlays. Yes, now we have anti-competitive. That means they are going to protect all the the company's interest in trading and they encourage the companies to trade more or to produce more and to sell more in the market. But even though we have this particular kind of anti-competitive act and all, still we have some competition and still we have the dominating positions in another factor, that is competition Act 2002 outlays. So this domination will be there wherever you go. Wherever we go, the competition will be there. The people will be competing with us, and they try to give competition with us by reducing the price or giving more quantity, or by giving more and more offers, buy one get one offer or buy two get two offer, like that. Dominance is one of the main aspects that competition law, sometimes referred to as antitrust law, addresses. So yes, it's also called as the antitrust law. A firm's or a group of enterprises' capacity to impact output or price in the pertinent market is referred to a dominance. Yes, here the people are going to dominate the market based on the price, or based on the quality, or based on the quantity of the product. So mainly we always focus on the price of the product. Based on the cost, what we'll do, we go and purchase the product. Sometimes instead of selling a product for 200 rupees, what we'll say, just we will say 199. It's a psychological pricing. That means based on what you price, in what way we are going to price, we can attract more number of customers. Instead of selling it for 200, if you say 199, instead of selling it for 1000, if you say 999, okay, your opponent is setting a price of 1000, but you are selling it for 999, 999, then more customers will be attracted towards your product. That is the strategy what they'll use to dominate in the market. The term abuse describes when someone uses their authority improperly. In case if any person is using their authority improperly, and if they are misguiding, or if they are not working properly in the market, at that time they'll be called as abused. So that is why the term abuse describes when someone uses their authority improperly. If particular person is not using their authority in a proper way, then it is called abused, or exploitly or excessively. That means if person is not using the authority properly, or exploitly or excessively, then it is called abuse. To misuse, exploit, or overuse a dominating position in the relevant market, one must do so. Section 4 subsection 2 of the Competition Act 2002 states that to determine whether a business holds a dominating position, or all of the following factors must be taken into account. Yes, to say that one business is dominating the other business, or that business is very dominating in the competitive market. So to decide that whether that business is dominating or not, we are supposed to look into few factors. So which are those few factors? The size and resources of the company. Yes, if you feel that that company is dominating more, then based on these reasons, we are going to decide whether that company is more competitive or not, based on the size and resources of that company, the dominating company, the size and importance of its adversaries, and the company's financial strength comprises competitive advantage over other enterprises, such as the appropriate patent license and permits, and vertical integration of the company, including any forward or backwards integration, and having access to sources of goods or raw materials is essential for competing successfully in a market when such supply is dependent on other companies, and being able to enter markets for goods or services when there is a dependency on other firms is essential for effective competing those markets. Yes, effective competing in those markets. So these are all the factors we will be considering whether it is competing or not, whether it's dominating or not. Next, Competition Commission of India members composition. Yes, so overall the members are going to be there in the Competition Commission of India. The member of the Competition Commission of India are appointed by the central government. Yes, the members of Competition Act or Competition Commission of India are going to be appointed by the central government. The Competition Commission of India is currently functional with a chairperson and 2 members. Yes, at presently there is a chairman and 2 members along with the chairman. So this Competition Commission of India is consisting of 3 members, 1 chairman and other 2 members. The commission used to consist of 1 chairperson and minimum of 2 members and maximum of 6 members. So here they can appoint one person as the chairman, and they have to appoint minimum 2, maximum of 6 members along with the chairman to call it as a Competition Commission of India. Next, this has further been reduced to the 3 members and 1 chairperson by the cabinet. This move was taken to produce a faster turnaround in hearing and speedier approval, thereby stimulating the business processes of corporates and resulting in greater employment opportunities in the country. So here, earlier we had 1 chairman, 2 members, maximum of 6, but now they reduced it to 3. The 1 person is going to be the chairman, who is from the cabinet. So why they did this? In order to reduce all the work burdens, or in order to reduce the flow of authority, and to make sure that there is a speedy approvals for all their requirements. Next, the chairperson and the members are usually full-time members. Yes, under the Competition Commission of India, whoever is going to appointed as a member and chairperson, they are going to be a full-time members. That means they are going to be full-time. They are not part-time. They are full-time. They are supposed to work for the whole year. The eligibility for the commission, that means what and all the eligibilities the chairperson is supposed to fulfill. A chairperson and every other members shall be a person of ability, integrity, and who has been or is qualified to be a judge of High Court, or has special knowledge of and professional experience of not less than 15 years of international trade. So to be a chairperson, the eligibility is, you should be the judge, or you should have some experience of 15 years. You should have experience of 15 years in international trade or economics or business, commerce, law, finance, accountancy, or in management, or in industry, or in public affairs, or in administration, or in any other matter which in the opinion of the central government may be useful to the commission. So person who is having this qualification, he can be the chairperson of the Competition Commission of India. So with this, I'm going to wind up this session. I'm going to come up with a few more new topics in the upcoming session. Until then, thank you all. Have a nice day. Namaste.